Office of General Counsel, Federal Election Commission, 999 A Street, Northwest, Washington, D.C. 20463. Dear Sir or Madam, regarding several articles recently published on a website known as www.zpolitics.com, criticizing and disparaging fellow Georgia U.S. 9th House District challenger Paul Brown, certain facts have come to our attention. If proven true under FEC procedures, and we expect they will, we believe the re-election campaign of U.S. Representative Doug Collins and Representative Collins himself have knowingly and willingly committed several counts violating FEC regulations, the federal laws under which they derive, and very likely the rules of the House Ethics Committee. Specifically, the facts point to the likelihood that Representative Collins' campaign and Representative Collins himself stand knowingly and willingly in violation of FEC Regulation 11 CFR 110.11 B1, which requires, on a public communication that is authorized and paid for by a candidate or his or her campaign committee, the disclaimer notice must identify who paid for the message. Here are the facts we allege and understand to be true. 1. On Tuesday, March 1, 2016, at approximately 1:30 p.m., prospective 9th District U.S. House candidate Paul Brown placed a call to Georgia 9th District U.S. Representative Doug Collins on his private phone, a call which Collins shortly returned, the purpose to inform the congressman that the former would run against him in the May 24, 9th District Republican primary. That information comes directly from a conversation with candidate Brown. 2. On Thursday, March 3, 2016, 2 days later, a website known as zpolitics.com published an article purporting to be independent news entitled, "Paul Brown Will Run for Congressional Seat, Despite Federal Grand Jury Investigation." In that article are numerous statements disparaging and attacking Paul Brown, his record, and intentions, those statements accruing obvious benefit to Representative Collins' re-election campaign. Importantly, the article refers directly to the private phone call candidate Brown made to Collins 2 days before. Because it was private, and because only Collins and Brown knew about the call, the unnamed source for that information could only have been Collins himself, a fact establishing a link between Collins personally and his knowledge of the writing of the March 3 article purporting to be independent news. 3. zpolitics.com, as it turns out, is not an independent news and commentary website. Instead, zPolitics is listed as the personal property of Jason J. Williams, founder and managing principal at the Stone Ridge Group, LLC, a campaign consulting firm heavily involved in Representative Collins' past campaigns, as well as one that appears and is likely to be running material aspects of his 2016 campaign. We expect the first quarter 2016 Collins FEC campaign filings will demonstrate that the Stone Ridge Group has been receiving payments for services rendered on an ongoing basis for Collins' re-election campaign during the time in question. 4. Any payments the Collins campaign makes to the Stone Ridge Group constitute payments accruing to the benefit of the Stone Ridge Group owner Jason Williams, personal owner of zpolitics.com, who as its owner is solely and personally responsible for that website's content, and who is therefore personally responsible for publishing the March 3 supposed news article disparaging candidate Paul Brown and benefiting Representative Collins. Because the Collins campaign makes payments to Jason Williams through a media entity Williams owns, and because intern Williams posts news and commentary accruing to the favor of Collins' campaign, while disparaging Collins' opponent on another media entity he owns, but without campaign disclaimers, we view this ongoing, purposeful process as nothing less than information laundering, an attempt to deceive the public, posturing partisan campaign materials as independent news and commentary. Obviously, there is only one way for Jason Williams to have known about the private phone call between candidate Brown and Representative Collins, and that would be that Collins conveyed that information to him. Thus we believe the March 3 published article constitutes a public communication that is authorized and paid for by a candidate or his or her campaign committee. That being the case, 11 CFR 110.11 B1 further requires that a disclaimer notice must identify who paid for the message. Because the paid-for news article did not offer a disclaimer, we believe this communication is in violation of FEC regulations. 5. We believe a second count violating that same regulation can be found in the place of a follow-up Z-Politics article, one dated March 10, 2016, entitled, "Paul Brown Announces That Attacks Begin to Fly in the 9th Congressional District." That second, supposed independent news article is even so bold as to provide a link to a vicious 60-second sneak preview radio campaign commercial subsequently to be launched against candidate Brown. The radio commercial produced and noted as authorized and paid for by the Collins campaign. Importantly, however, we believe the article itself, containing numerous disparages against candidate Brown, as well as a link to the vicious radio ad attacking Brown, was paid to be published, either directly or indirectly, by the Collins campaign. We believe it was another paid-for publication in the same manner as the first count, the payment going to the Stone Ridge Group, the Stone Ridge Group appearing to most of the world as a legitimate recipient of the funds, the Stone Ridge Group, and its owner Jason Williams actually, however, serving as nothing less than an information laundering agent between the Collins campaign and Z-Politics, neither of these fake news reports offering campaign disclaimers. 6. We believe a third count regarding the Collins campaign and Representative Collins personally violating 11 CFR 110.11 B1 occurred on April 7, when still another article, one entitled, "Paul Brown's Former Chief of Staff Was Just Indicted," appeared on zpolitics.com. This was yet another article serving Collins' re-election campaign purposes, showing Collins' opponent Paul Brown in a bad light. And we believe it should not be lost on the FEC that none of these articles simply linked to legitimate news services offering objective assessments of the circumstances. Instead, all of these articles were purposely authored and produced in-house, credit given each time to staff, this even though several Z-Politics staff writers are listed by name on one of the website's pages. We expect that an FEC investigation will uncover that all of these paid-for news articles attacking Collins' opponent Brown will have been written by the Stone Ridge Group campaign consultants rather than any of the staff reporters working the beat for Z-Politics. We believe that each of the March 3, March 10, and April 7 ZPolitics.com articles, paid for by the Collins campaign to the Stone Ridge Group, and offered to an unsuspecting public as independent news and commentary, but with no campaign disclaimers, constitute prima facie evidence of violations of the regulation referred above. Furthermore, we do not believe these paid campaign materials, published as independent news and commentary in ZPolitics.com, by the Collins campaign, but without campaign disclaimers, could have been placed in the public eye without Representative Collins' personal knowledge and authority. Evidence supporting our belief is that, on Collins' personal Facebook page, he shared the March 3 Z-Politics article written by an unnamed third party known only as staff, but which contained information that only he could have known. And he did so without raising the question concerning how an anonymous staff writer for Z-Politics might have known about a private phone call between Collins and candidate Brown. Were Collins innocent in all of this, he would have recognized an information leak in his campaign and taken steps to distance himself and to set the record straight. In short, heads would have rolled. Collins' prior knowledge of the relationship between the owner of his paid campaign consulting firm and ZPolitics.com, which he also owns, without calling for an investigation, or at least offering an apology to all affected, is cemented into place by Collins' own personal actions taken to disseminate the article's content deeper into the public mind with the use of his own personal Facebook page. We believe the FEC investigation will conclude that Representative Collins had ongoing knowledge of campaign materials being posted as articles purported to be independent news and commentary, appearing in Z-Politics on March 3, March 10, and April 7. We also believe the FEC investigation will conclude that Representative Collins understood that when he placed this media content on his social media, he was placing materials designed by his campaign consultant to further his election chances, rather than independent news and commentary. We therefore believe a thorough FEC investigation of these matters will conclude that the counts discussed above constitute willful, knowledgeable and deliberate actions on the parts of the Collins campaign, and Representative Collins himself, to violate FEC regulations and the laws under which they derive regarding the required use of campaign disclaimers. The evidence suggests 9th District U.S. Representative Doug Collins knowingly offered up paid campaign materials and infomercials with no disclaimers to an unsuspecting public, seeking to cultivate a sympathetic advantage over not only primary opponent Paul Brown, but also the undersigned candidates Mike Scupin and Bernie Fontaine. That is because unwary voters who believe the paid-for fake news the Collins campaign might place before them would also be more likely to vote for Collins and any of his challengers. And to add to the egregious nature of Representative Collins' actions and motivations, Collins presently represents each of his primary opponents in the U.S. Congress. That being the case, beyond the campaign, Representative Collins owes a personal duty to represent all challengers honestly and forthrightly in the discharge of his official duties and campaign activities. We do not condone the practice of willfully deceiving our fellow voters and the citizens whom Mr. Collins also represents. We believe that any such activity on Representative Collins' part, or on the part of his campaign, which seeks to willfully deceive the voters to believe paid campaign literature published as independent news and commentary, or as infomercials placed in public view without campaign disclaimers, such as we have evidenced here, also constitutes a count in violation of House ethics rules. We plan to make a similar complaint to that body. Therefore, in the interest of campaign fairness, and pursuing adherence to all federal campaign regulations and the laws under which they derive, we ask the FEC General Counsel to investigate the financial and contractual ties between Georgia 9th District U.S. Representative Doug Collins and/or his election campaign, and the Stone Ridge Group, and/or zpolitics.com. Furthermore, we ask the General Counsel to investigate the Stone Ridge Group and its managing principal, Jason Williams, to confirm any ownership, financial, legal or contractual ties he or his firm may have with zpolitics.com. Secondly, we ask the FEC General Counsel to investigate the events and circumstances detailed in this letter to determine whether these facts constitute willful efforts on the part of the Collins campaign and/or Representative Doug Collins himself and/or the Stone Ridge Group and/or Jason Williams and/or his assigned personnel to 1. Deceive the voters of Georgia's 9th District. 2. Violate FEC regulations regarding the use of campaign disclaimers, and thereby 3. Violate federal laws from which these FEC regulations derive, and if so, 4. Determine proper penalties, sanctions, or punishments for all who took part in these acts, to the extent that the laws allow. Thirdly, we respectfully recommend that the individuals responsible for designing FEC regulations look deeply into the practices of campaign consultant zoning and utilizing ancillary media outlets to launder campaign materials, to place them into the mind of an unsuspecting public without campaign disclaimers. We believe a distinctly possible conflict of public interests exists when temptations to step outside of ethical campaigning naturally arise, and these kinds of vehicles are available for exploit. Finally, in the case before you, to ensure fair and proper campaign and election outcomes in the future, we believe it is essential that any violations of FEC regulations by the Collins campaign or Representative Collins personally or his campaign consultants, especially purposeful violations, be met with swift and certain consequences. Sincerely, Mike Scupin, Candidate, Georgia 9th District U.S. Congress. Bernie Fontaine, Candidate, Georgia 9th District U.S. Congress.